You're listening to the Valley Current.
I want you to imagine, just for a second, that you are the CEO of the most valuable company on the planet. You just survived this massive bet-the-company antitrust lawsuit.
Right, a total existential threat to the business.
Exactly. And the judge hands down the ruling, and you win. I mean, you win 90% of the entire case. You defeat every single federal monopoly claim aimed at your core business model.
You're definitely popping the champagne at that point.
Oh, absolutely. You even win a $3.6 million counterclaim against the very company that sued you. It looks like a total victory.
But, there's always a catch.
Yeah, there is, because then you look at the tiny 10% you lost, and because of how your finance and legal teams decide to, handle that one minor defeat.
Which is where the trouble always starts.
Right. You end up facing a criminal contempt referral to the U.S. attorney. Your vice president of finance is accused of perjury, and you trigger a multi-billion-dollar showdown at the United States Supreme Court.
It is honestly the ultimate cautionary tale of winning the battle but completely losing the peace. It really demonstrates how aggressive compliance engineering can threaten the core of a $100 billion revenue engine.
Welcome to this deep dive. I'm your host, and today we are taking an exclusive look into the epic legal fallout of Epic versus Apple.
And I'm your resident legal analyst, thrilled to be here to unpack this incredibly messy aftermath.
So we are pulling all our facts today from this incredibly detailed legal bulletin. It was published by Computer Law Group LLP on May 22, 2026, and authored by Jack Russo.
It's a fantastic source, really gets into the weeds of the court documents.
Yeah, it does. And our mission for this deep dive is to unpack the high-stakes difference between the strict letter of the law and the broader spirit of the law.
Which is a multi-billion-dollar difference in this case.
Exactly. We're going to look at secret internal communications from inside Apple, emails and Slack messages you usually never get to see, and we'll show you how their attempt to engineer a way around a single sentence in a judicial order just backfired spectacularly.
It's fascinating because this isn't just dry legalese. This is an inside look at the secret war over how you pay for every single app on your phone.
Right. It affects everyone listening. The stakes involve the fundamental architecture of the digital economy. But let's set the stage with that initial 2021 bench trial before Judge Yvonne Gonzalez-Rogers.
Yeah, that was a grueling 16 days in court. Epic Games was really throwing the legal kitchen sink at Apple.
They really were. We are talking Sherman Act, monopoly claims, Cartwright Act claims. Epic basically accused Apple of arguing that Apple was illegally forcing any developer who wanted to use the iOS App Store to also use Apple's proprietary payment processor.
And of course, taking that famous 30% cut.
Right. But Apple batted almost all of it away. 9 out of 10 counts, Apple wins outright.
Fending off those federal claims is just a staggering defense victory in an antitrust case of that magnitude. The general consensus was that Apple's walled garden survives completely intact.
They even won that $3.6 million breach of contract counterclaim over Epic's Project Liberty, right? That was the secret hotfix Epic snuck into Fortnite to bypass Apple's payment system.
Exactly, yeah. Epic broke the rules, Apple caught them, and the judge agreed Epic had to pay up.
Right.
But Apple lost count 10.
Right, count 10. The California Unfair Competition Law claim, or UCL. Specifically, this dealt with Apple's anti-steering provisions.
Which are the rules that stop app developers from telling you, the user, that you could maybe buy a subscription cheaper on the developer's own website.
Yeah, keeping you in the dark. So why did Apple lose that one specific state-level count when they so successfully fended off all those heady federal antitrust claims?
Well, what's fascinating here is the mechanism at play. It revolves around the tethering standard under California law. You see, federal antitrust laws are super rigid.
Like you either have an illegal monopoly or you don't.
Precisely. But the California Unfair Competition Law has this unfair prong that is intentionally designed to sweep much more broadly. It's built to catch what courts call incipient violations.
Incipient violations, meaning the law is designed to catch bad anti-competitive behavior before it grows up into a full-blown federal monopoly.
You nailed it. The district court looked at Apple's anti-steering provisions and concluded they were preventing informed consumer choice.
So by keeping iOS users blind to cheaper payment alternatives outside the app, Apple was stifling competition in its infancy.
Exactly. So while Apple's conduct didn't cross that strict mathematical line of a federal monopoly violation, it violated the policy and the spirit of competition.
So the judge issues a permanent injunction based entirely on that single unfair competition claim. And I was reading the source material on this injunction, and I almost did a double take.
Oh, because of how incredibly short it is.
Yes. This is a case involving billions of dollars, and the operative text of this injunction is roughly 75 words. It sits on a single page.
It's remarkably brief.
It basically just says Apple is permanently restrained from prohibiting developers from including external links or communicating with customers, and that is it.
Right. The document is completely, utterly silent on what Apple could charge for those links or how the links should be formatted.
Or whether Apple could throw up huge warning screens before a user clicked them. It just says, let them link.
And that silence, that 75-word silence, represents the textual heart of everything that went wrong for Apple over the next 5 years.
They saw a loophole.
A massive loophole. They looked at that command to allow links and saw a way to engineer around it to protect their bottom line.
Okay, let's unpack this strategy. Winning 9 out of 10 counts and then getting tripped up on this one rule. It's like running a grueling 26-mile marathon, crossing the finish line in first place, and then getting disqualified because the referee says your shoelaces were tied in an anti-competitive knot.
That's a great way to put it.
Right, you won the race.
Oh.
But instead of just fixing the shoelaces and taking the gold medal, Apple decides to invent a brand new, highly complex type of shoe just to spite the referee. Did Apple willingly walk into this trap, or did they genuinely think that 75-word silence was a blank check?
Well, the internal evidence suggests they treated the judge's injunction exactly like a tax statute.
Oh, wow. Like finding a loophole in the tax code.
Exactly. Think about how major corporations approach taxes. You read the strict, literal text, and then you engineer your business structure to comply with the exact letter of the rule while entirely avoiding the intended financial impact.
Wow. Okay, so they prioritize protecting their massive revenue stream over the actual spirit of the court's order.
And we really need to emphasize how massive that stream is. I mean, in fiscal 2025, Apple services revenue hit $109.16 billion.
Billion, with a B. And the source notes that in just the first quarter of fiscal 2026, they hit an all-time record of $30 billion in a single quarter.
Right, so the financial incentive to protect that ecosystem was just overwhelming. So in January 2024, Apple rolled out their compliance plan.
The famous StoreKit external purchase link entitlement.
Yes. They technically allowed external links, which satisfied the literal 75 words of the injunction. But they loaded those links with extreme friction.
The friction is unbelievable. A developer couldn't just drop a link in their app. They had to formally apply for this entitlement.
And they had to use one of 5 rigid URL templates dictated by Apple.
Yeah, and the link had to be in plain text. You could only put it on one single page, entirely outside of any purchasing flow.
Plus, Apple forced developers to strip out user-identifying parameters.
Which is huge. That meant the user couldn't even auto-log in once they clicked the link. They had to start from scratch on the website.
And if a user actually found this buried plain text link and tapped it, Apple threw up a massive, full-screen, interstitial warning screen.
Are you sure you want to leave the safety of Apple? But honestly, the craziest part of all of this is the math. I'm struggling to understand the internal corporate logic here.
Ah, yes. The mathematical design of the link is really the defining feature of what the court viewed as malicious compliance.
Here's where it gets really interesting. Apple's finance team, filled with some of the smartest people on earth, designs a policy that says, okay, if a user clicks this scary text link and buys something on your website within 7 days, you don't have to pay our standard 30% commission.
They offer a discount, theoretically.
Right. They say you only have to pay a 27% commission or 12% for small businesses. So Apple is offering a 3% discount to use the external link.
But wait, if a developer uses an external link, they have to process the credit card payment themselves, right?
Exactly. And the standard third-party payment processor charge is 2.9% plus 30 cents per transaction.
So when you do the math...
When you add the 27% Apple fee, plus the 2.9% external processor fee, plus the 30-cent flat fee, the 3% discount vanishes entirely.
It costs a developer exactly the same, or even more, to steer the customer away from Apple's system.
It's absurd. This is like a store offering a discount that requires you to pay a cover charge just to enter the clearance aisle. Did Apple's finance team really think the judge wouldn't do the math?
Well, they didn't justify it as compliance in private. They justified it as revenue protection. The district court actually found that Apple's finance team calculated exactly this result before adopting the policy.
So they knew it was economically useless.
They designed the system so external links would be economically extinguished from the start, and the internal Slack and email traffic from Apple employees completely confirms it.
Yeah, I have the quotes right here from the bulletin. In a November 2021 Slack thread, an Apple employee is workshopping the warning screen language and suggests the phrase external website because it, quote, sounds scary, so execs will love it.
It's pretty damning when you see it in writing. Another employee proposed making the warning screen even more discouraging, and the response in the Slack thread was literally, ooh, keep going.
Keep going.
Just incredible. And then you have Phil Schiller, the legendary Apple executive. He sends an email stating bluntly, clearly I am not on team commission/fee.
Right. He was actually advocating for straightforward compliance, but he was overruled.
Overruled by CEO Tim Cook and Chief Financial Officer Luca Maestri.
Protecting that $100 billion services revenue trumped the internal voices urging good faith. Apple's leadership essentially bet that the judge would act strictly as a civil referee.
Meaning they thought she just read the literal text of her order, check the box that links exist, and move on.
Exactly, rather than enforcing the actual spirit of competition.
Well, the judge didn't just act as a referee. She became a punitive enforcer. By prioritizing revenue over the spirit of the injunction, Apple triggered an absolute judicial explosion in April 2025. Generational rebuke is what the source material calls it. Judge Gonzalez-Rogers was furious.
She issued a contempt order against a Fortune 10 company. She found clear and convincing evidence of a cover-up to maintain revenue, writing that Apple's compliance plan, quote, strains credulity.
You know, federal judges rarely call out corporate executives the way she did here. The individual culpability findings truly elevate this case into uncharted territory.
Yeah, the judge ruled that Apple's vice president of finance, Alex Roman, outright lied under oath to hide the truth about how those commissions were calculated.
And she explicitly wrote that Tim Cook ignored Schiller and chose poorly.
Chose poorly, wow. And the remedy she handed down was just brutal. Apple was permanently restrained from imposing any commission at all on linked-out purchases, 0%.
A total ban on extracting rent from those external transactions.
Plus, they were banned from using those scare screens. And the judge also stripped Apple of their legal privilege protections, saying it was not a close privilege call, which forced Apple to pay Epic's special master and attorney fees.
We should really explain the mechanism of that privilege stripping because it is severe. Normally, communications between a company and its internal lawyers are locked in a vault, completely protected by attorney-client privilege.
Right, the lawyers are a safe space.
But there is a legal mechanism called the crime-fraud exception. If a judge finds evidence you are using those lawyers to orchestrate a bad faith scheme or a cover-up, the judge can literally blow the vault doors off.
Oh, wow. So she determined the legal advice was being used to actively evade a court order.
Exactly. That is why she stripped the privilege.
And then she drops the ultimate penalty. She refers Apple and Alex Roman personally to the U.S. attorney for possible criminal contempt proceedings. The judge declared, and I quote, "This is an injunction, not a negotiation."
It's a massive escalation.
Wait, a criminal referral for a Fortune 10 company over app links? Isn't that the legal equivalent dropping a piano on a shoplifter? Is this unprecedented or just a judge flexing power?
Well, if the offense was just poorly designed app links, perhaps. But courts shift from being civil referees to punitive enforcers when a company relies on perjury and intentionally ignores its own internal compliance counsel.
Because it undermines the court's authority.
Precisely. A civil injunction relies on the losing party executing the order in good faith. When you prove you have no good faith, the court reaches for its most severe tools to compel obedience.
Naturally, for Apple, accepting a 0% commission meant voluntarily detonating their services business model. They literally had no choice but to appeal.
Right. They raced to the Ninth Circuit Court of Appeals, basically forcing an appellate panel to decide if Judge Gonzalez-Rogers' punishment had gone too far.
And in December 2025, the Ninth Circuit panel issues their decision, and they actually affirmed the contempt ruling.
They did. They agreed with the liability findings, they agreed with stripping the legal privilege, and they upheld the ban on the scare screens.
But they threw Apple one major lifeline, striking down that 0% commission rule.
Yeah, Ninth Circuit ruled that a 0% commission was too punitive. It crossed the line from a civil contempt sanction, which is meant to coerce compliance, into a criminal contempt sanction, which is just meant to punish past behavior.
So they remanded the case back to the district judge with instructions to fix a non-prohibitive rate.
But they put a very strict cap on it. Apple could only charge based on the costs that are genuinely and reasonably necessary for the coordination of external links.
And crucially, the Ninth Circuit explicitly stated that Apple's security and privacy features do not count as necessary costs.
That is a massive caveat.
The Ninth Circuit is essentially telling Apple, you can charge a toll for the physical road you built to connect the user to the external website, but you cannot charge developers for the overarching weather of your secure ecosystem once they leave your property.
That's a really good analogy.
So, what does this all mean for Apple's core identity? Their entire brand, the reason people buy iPhones over competitors, is built on privacy and security. By the court saying you can't charge for that, aren't they essentially dictating how Apple designs its own operating system?
If we connect this to the bigger picture, it forces a massive structural separation. The appellate court is attempting to thread a very difficult needle here.
Between punishing bad faith and regulating tech.
Exactly. They want to punish Apple's blatant bad faith, but they recognize the legal limits of civil contempt. They're concluding that privacy and security, while valuable, cannot be used as a justification to extract rent on transactions that happen entirely outside Apple's ecosystem.
And Apple wasn't winning any sympathy at the highest levels of the judiciary either. In May 2026, Apple filed an emergency stay application directly to Supreme Court Justice Elena Kagan.
A very aggressive move.
Right. And normally, an emergency application triggers a whole process of review and counterarguments. But Justice Kagan denied it in under an hour. She didn't consult the full court. She didn't even wait for Epic Games to file a reply brief.
As Amy Howe from SCOTUS blog pointed out in the bulletin, Kagan acting that swiftly, entirely by herself, is a tremendous signal. She showed zero sympathy for Apple's posture.
And Epic's PR team immediately celebrated it as the definitive end of Apple's delay tactics.
But of course, Apple wasn't done.
No, with the emergency stay denied, they launched their final Hail Mary. On May 21st, 2026, Apple files a formal petition to the Supreme Court, led by a powerhouse legal team, including former Solicitor General Gregory G. Garr.
They brought out the big guns, and they are raising two massive constitutional questions that could reshape federal civil procedure.
Let's break this down. What's question one?
Question one directly attacks the contempt standard itself, highlighting a clean circuit split across the country. Did Apple violate the strict literal text of the injunction, or did they violate the spirit of the injunction?
Because the injunction was so short.
Right. Apple argues that under Federal Rule of Civil Procedure 65 Des, and in jurisdictions like the First and Second Circuits, the text must be clearly and unambiguously forbidden to justify contempt.
But the Ninth Circuit uses a different standard, right? Tracing back to a case called Sea Shepherd.
Exactly. The Sea Shepherd standard allows judges to look at the overall spirit of the order. Apple's petition argues it is fundamentally unfair to hold a company in contempt and refer executives for criminal prosecution based on an amorphous, know-it-when-you-see-it feeling from a single judge.
Okay, that makes sense. But what about question two? It brings in that recent Trump versus Tesa Supreme Court decision.
Yes, the June 2025 Tesa decision. This deals with the limits of universal injunctions. To understand this, we really have to look at the historical power of the federal courts.
Right. So CASA ruling fundamentally asked, when does a judge have the power to issue a rule that applies to millions of people who aren't even in the courtroom?
Because historically, under the Judiciary Act of 1789, courts were only supposed to fix the specific problem between the two specific parties standing right in front of them.
But the Epic injunction doesn't just protect Epic. It protects roughly 34 million Apple developers worldwide, including massive companies like Microsoft and Spotify, who had absolutely nothing to do with Epic's lawsuit.
This raises an important question. The Ninth Circuit allowed this universal application through what Apple calls an ill-conceived antitrust exception to this ASA ruling.
I have to admit, Apple has a compelling point here. I mean, how does a single judge in Oakland get to act as the global App Store regulator based on one state's competition law?
It is a massive stretch of jurisdiction.
Right. Why should an app developer sitting in Tokyo or Paris have their business governed by a California consumer protection law? Isn't that massive overreach?
It definitely highlights the tension between federalism and the reality of modern technology platforms. If a court finds that the core architecture of a unified global platform like the App Store violates a state's competition law, how do you remedy that just for Epic Games without altering the platform for everyone else?
Because you can't realistically build a bespoke app store just for one developer.
Exactly. It is a genuine legal puzzle.
So what are the odds the Supreme Court actually takes this case? I know they reject most petitions.
The baseline grant rate for paid Supreme Court petitions is usually only about 3 to 5%. But because Apple has presented a clean circuit split on the contempt standard and a massive constitutional question regarding universal injunctions,
the source material estimates the probability of a grant jumps to 15 to 25%.
Right. The court frequently looks for opportunities to clarify its own recent rulings, like CESA. Given the clean legal questions and the massive economic stakes, it is a perfectly calibrated read by the author.
So, for you listening, why should you care about this procedural chess match? Because this isn't just a squabble between two tech giants. This is a battle over the entire architecture of the digital economy.
It's about how a $30 billion a quarter machine operates.
Exactly. And the ultimate lesson for every company watching is that winning 90% of a lawsuit does not give you a license to compliance engineer your way out of the 10% you lost.
Because when you try to outsmart a judge's order with bad faith friction, 27% fees, and scare screens, you risk blowing up your entire business model. An injunction is what a reasonable court reading it in good faith would understand it to require.
Not what the most aggressive in-house lawyer can construct around its commas.
Exactly.
But before we wrap up, I want to leave you with a massive piece of context that builds on everything we've discussed today, but takes it in a completely different direction.
It completely reframes the narrative, doesn't it? Apple's pricing power is no longer just an American legal question. It is structurally constrained on at least 5 continents.
Right. Consider this. Even if Apple somehow wins this Hail Mary at the Supreme Court, how will they handle the December 2025 CADE settlement in Brazil, which strictly caps steering commissions at 15%?
Or Japan's new Mobile Software Competition Act.
Yeah, and the European Union just hit them with a €500 million fine under the Digital Markets Act, and the UK has handed down a strategic market status designation.
They are fighting a multi-front war everywhere.
So as you go about your day, mull this over. Is this entire U.S. Supreme Court battle, with its criminal referrals and high-priced lawyers arguing over the spirit of a 75-word sentence, just a noisy sideshow to an unavoidable global regulatory avalanche? Thank you for joining us on this deep dive. Keep questioning the spirit of the rules around you.
Tune in next time on The Valley Current.